confessions are voluntary. And race and resources, just quickly, in the United States, America jails 3% of its black population, and in the United Kingdom, only 1% of the black population is imprisoned. And something interesting to note that we'll talk about in a little bit, resources, the United Kingdom, they have suspects and inmates have more access to legal information before conviction. And what's interesting is in the United States, many innocent people will waive their Miranda rights because they believe that their innocence will prove within the interviews and the interrogations.
Okay, black men are highly represented in America's prison. What are the cause and why do so many lead to false confessions? According to Roosevelt and Humphrey, American police practice and wrongful convictions based on racism worked to wrongly exclude and wrongly include suspects in an investigation. Roosevelt and Humphrey claims blacks are 31% more likely than whites to be wrongfully convicted. Furthermore, blacks compose 12.9% of the American population, yet blacks account for 49.4% of 1.3 million residents of American jails and prisons. Although blacks make up only 12.9% of the country, they are the highest percentage of wrongful conviction at 2.5%.
25%, right?
Yeah. Yes, excuse me. 25.5%. Thank you. Comparative. In Chicago, the Relief Commission was established in 2009 after reports and allegations of Commander Bergs and other officers of torturing 112 black men and counting. Recently, the Commission recommended 5 cases for review to determine if further actions are warranted and examining evidence to support the allegations. The UK comparative, the British section of the International Commission of Juries estimated that 15 cases of wrongful conviction occurs each year in the United Kingdom. 20% of the convictions are contested in the United Kingdom because of the cases of miscarriages of justice in the 1997. An independent commission was formed and reviewed cases of wrongful conviction. The Criminal Case Review Commission reviewed post-appellate cases of wrongful convictions in England, Wales, and North Ireland to determine which case has enough evidence to grant an appeal. The Criminal Case Review Commission first annual report showed that it made 12 referrals to appeal courts and 7 cases have been reviewed, resulting in 6 cases being overturned.
We just had a few things to talk about. Just some reforms.
We were misled by this.
In the United States, one thing that can, that innocent people have to fear is the death penalty. In the United States, 17 states plus DC have abolished the death penalty, but that means 33 states, that's still a possibility for somebody who is in jail on a false confession, who has been wrongfully convicted. In the UK, Protocol 13 has abolished the death penalty completely. Both the UK and the US have innocence projects. The IPRA, which was mentioned earlier, is interesting and can be compared to the NCIA, which is the National Policing Improvement Agency in the UK. Both agencies have intentions to better the system, but what is important to note is that in the United States, the Independent Police Review Authority, they take on complaints about incidents that have already occurred, whereas the National Policing Improvement Agency has more preventive techniques that they use. And then the Crown Prosecution Service, as is in the UK, and then The United States has yet to have anything comparable to it, as well as in the United Kingdom, the Innocent Project, which helps people that have been exonerated. And then, importantly enough, the United States, only some states require interrogations to be recorded, and in the UK, all interrogations are videotaped. Thank you.
Yeah, again, thank you all for such great presentations. Again, this is it's an issue that people within the criminal justice system, particularly on the defense side, are so sensitive to, but it's another issue that is crying out for more just general education, and that's really, I think, the ultimate answer that we might be able to, approach a solution to these chronic problems. I was really interested in all of the presentations, but I'll just single out Ms. Arrington's about the relationship. Don't worry, won't put you on the spot. But the relationship between race and coerced confessions, because that's, speaking of the epicenter of wrongful convictions, this is really Chicago's story, and we have to, take ownership of it. And what's so fascinating about the relationship to me is that you have a segregated police force, especially in Area 2, policing over a segregated population. And it really comes down to, in my view, just a lack of empathy between the police or from the police towards those who they're supposed to be serving, combined with an assumption that they know everything about the population and they can identify the guilty just by looking at them. So it's this situation where an overconfidence in an ability to tell a guilty person is coupled with a real ignorance of the people who they're supposed to be serving. And I think that's the legacy of John Burge and everyone working on him. But fantastic job, thank you.
Just as a follow-up to the John Burge, I can segue nicely into this. I thought it was great that you mentioned the Illinois Torture Reform Commission, and just as a follow-up to that, one of the problems that none of you really talked about, but I think is most evidenced by what's been going on with the Torture Reform Commission, is that sometimes there isn't legislative support for reforms, and oftentimes there are huge struggles with funding. The commission has been struggling with funding since day one, and got its funding pulled last year, and then we submitted a petition, and it was reinstated, but cut. And so these are the kinds of struggles that you don't necessarily think of right off the bat, but can be absolutely fatal to an effort to reform.
I'll just say what a great job you all did, and just add to, I think that while it can be difficult, excuse me, and frustrating because we don't have the resources, or we might have the system reluctant to start recording all interrogations, etc. I think that Emily, you spoke about internalized false confessions, and I think it's so important too to focus on that if people know their rights at the beginning and know to ask for an attorney and know to say, I'm just going to stay silent, because many people don't understand how anyone could ever falsely confess, but yet actually come to believe that you committed a crime that you didn't commit. People have a much harder time even wrapping their minds around that, and I think that plays so nicely into the memory work that Jonathan and Erica talked about earlier. But I think that it's important, and I know that Northwestern has a Know Your Rights group, I believe. That might be something that they do. Educating young folks about knowing their rights, and I'm glad to see that you all know yours. So good job.
All right, nice job, you guys. So it just so happened that one of the next people out had their presentation already up there. So just to let you know, we're going to group the next three together as well, because Abigail Moore, Lindy Dignan, and Clay Samba are all doing work on the adversarial system. And then after those three, we have one final one that actually does a nice job of tying much of this together through the lens of increasing pieces toward the LGBTQ community. So that'll be next report after these three. But we'll have some comments on the
Hello, my name is Abigail, and I'm going to be discussing prosecutorial misconduct comparatively between Chicago and London. And my main research question was, why does prosecutorial misconduct exist in the first place, and what forms does it take? And for the purpose of this study, I define prosecutorial misconduct as when prosecutors abuse their power to convict an individual without sufficient evidence to prove their absolute guilt, and also when prosecutors purposely manipulate the courtroom as an attempt to win an outcome of a case. I think it's really imperative to compare the adversarial system and the inquisitorial system. The adversarial system is practiced here in the United States, and some differences are there are pretty big disparities between public defenders and prosecutors, and those disparities range from fiscal to prestige to lack of mobility. And I think this is important. This gives prosecutors a chance to perform misconduct because a lot of times public defenders can be overworked and it gives prosecutors the upper hand. This isn't necessarily the case in the inquisitorial system. There's a lot more equality between prosecutors and defenders. Also in the adversarial system, judges are elected, and so there's an incentive for prosecutors to have high conviction rates and have outstanding win-loss records. But in the inquisitorial system, judges are appointed, they have an application process and an interview process, which makes it more fair. Also in the adversarial system, the judges and the jury are more passive, and they act more as referees between the prosecutors and the defenders. But in the inquisitorial system, the judges and the jury are active, the judge is participating in questioning, and they can also have previous knowledge of background information, what's happening in the case. A big thing that takes place in the adversarial system that doesn't exist in the inquisitorial system is prosecutorial immunity, and I'll touch on that in a few moments and more in depth. And also in the inquisitorial system, barristers have experience